Court is calling 2019 CR 3230 and 2018 CR 2419, State of Texas versus Michael Edward Cardenas. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
For the defense?
Ed Piker from Mr. Cardenas.
And are you Michael Edward Cardenas?
Yes, ma'am.
And each of the cause numbers, I'm showing you what's entitled motion to enter adjudication of guilt, first amended motion to enter adjudication of guilt, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review those documents with your attorney? Did you understand them? All right, and cause number 2019 CR 3230, are you the same Michael Edward Cardenas, was placed on deferred adjudication of sexual assault child on June 7, 2019 for a period of 6 years? Is that you? And are you the same Michael Edward Cardenas who was placed on deferred adjudication in 2018 CR 2419 for the offense of evading arrest detention with a vehicle on June 7, 2019 for a period of 6 years? Is that you?
Yes, ma'am.
State, are you proceeding on the same allegations in each of the motions?
Yes, Your Honor.
Defense, any objection to your client's answer be the answer for both motions?
No, I don't object. No objection to that.
All right, state.
Violated condition number 1, on or about the 31st day of January 2022 in Bear County, Texas, the defendant Michael Edward Cardenas committed the offense of assault in violation of condition number 1.
Judge, we did not agree on which one it was going to be, but I said we weren't going to plead true to that.
We'll just have him plea no.
Pick another one.
Ladies enter plea. So,
Okay. So how do you plead a violation of condition number 1? True or not true?
True.
Is it a true plea, counsel?
No, Judge.
Oh, he just played true.
Well,
Do you want him to plead not true to that
I
one?
want to plead not true to that. We can plead true to everything else.
that's fine.
All right, so state, are you withdrawing that being entered into the record, his plea of not true?
We have no objection.
All right, so state.
Violated condition number 5, in Bear County, Texas, defendant Michael Edward Cardenas, the defendant there failed to report to the supervision officer as directed for the month of February 2022 in violation condition number 5.
How do you plead to that? True or not true?
True. Say waiver may remain allegations.
Any objections to the state's waivers?
No, ma'am.
All right. Did you understand by pleading true to violation of condition number 5 in 2018 CR 2419, court could find it true, grant the motion, sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5 in 2018 CR 2419?
Yes, ma'am.
And did you understand by pleading true to violation of condition number 5 in 2019 CR 3230, the court could find it true, grant the motion, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5 in 2019 CR 3230?
Yes, ma'am.
Then, and that cause number, the court will find violation of condition number 5 true. And as previously stated, the court is finding violation of condition number 5 in 2018 CR 2419 true. Is there an agreement?
There's an agreed recommendation, Your Honor, and that is to grant the state's motion in each cause, enter an adjudication in each cause, and assess punishment of 5 years confinement in the Texas Department of Criminal Justice Institutional Division. And then the state is going to take into consideration CM cause number 95488, which is the assault case that's currently pending unindicted that he previously pled true to, but then withdrew.
Defense, is that the agreement?
Yes.
Mr. Cardenas, are you asking the court to follow that agreement? I'm sorry,
Yes, ma'am.
are you waiving your right to appeal? I'm sorry?
Yes, ma'am.
All right, then in cause number 2018 CR 2419, the court will follow your agreement, sentence you to 5 years in the prison, give you credit for any time served, take in consideration CM 95488. And in cause number 2019 CR 3230, the court will follow your agreement, sentence you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2018 CR 2419, and there's chapter 62 registration. Just one moment. Is there anything else from either side with regards to sentencing?
Not from the defense.
All right, in each of the cause numbers, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review those with your attorney? Did you understand them? And did you sign them? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction in each of these cause numbers, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record, Mr. Cardenas. Sometimes when people get sentenced, they think it is the end of the world because you have to do time. But you're still of an age where you can get out of prison and you can change your life. Do you understand?
Yes, ma'am.
All right, good luck to you. All right, is calling 2018 CR 11671, State of Texas versus Carvel Mayfield. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense,
Ted Wood for Mr. Mayfield?
are you Mr. Mayfield? Are you Mr. Mayfield?
Yes.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Carval Carey Mayfield who was placed on deferred adjudication in 2018 CR 11671 for the offense of possession of a controlled substance, penalty group 2, 4 grams to 400 grams on April 29th, 2019 for a term of 4 years? Is that you?
Yes, ma'am.
State.
Yes, Your Honor. Violating condition number 2 on or about the 27th day of April 2022. The Bear County, Texas, the defendant Carvel Carey Mayfield, the defendant there failed to submit to drug testing as directed by the supervision officer in violation of condition number 2.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violation.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Your Honor.
And what are you all requesting?
To deny the motion, continue the individual on his deferred, refer to felony drug court with a 2-year extension on his deferred. And judge, if he's not accepted in the felony drug court, it's an agreement that he will be sent to safety with an extension of 2 years.
All right, is that the agreement?
Yes, it is, Judge.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, you know yourself better than I do, better than your attorney does, and better than the state or probation does. If you want to be continued on probation, I will continue you. Otherwise, if you wish, I will revoke you and sentence you to 4 years. Which do you prefer?
No.
He declines the offer for TDC, Judge, but thanks you very much for offering it.
Okay,
Yes, ma'am. I'm sorry.
no problem. All right, the court is finding violation of condition number 2 true. The court will deny the motion, alter and amend conditions for an extension of 2 years, a referral to felony drug court. Do we need an updated TAP probation? TAP in custody. And if not accepted in felony drug court, then safe P. All right. We're off the record. Mr. Mayfield, you got to make a decision in your life. And your decision is, do you want to go to prison?
No, ma'am, I do not.
All right, then you need to start acting as though you don't want to go to prison by following through on your conditions. You understand?
Yes, ma'am.
The agreement that the state and the defense came up with, I don't have to follow that because they don't have a contract with you. You have a contract with the court. So if there's an issue, if you're struggling, let the court know and we'll see what we can do to help you. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Michael Edward Cardenas stood before the court facing the consequences of violating the conditions of his deferred adjudication. Originally placed on community supervision in 2019 for 2 separate felony cases, sexual assault of a child and evading arrest with a vehicle, he had been given a chance to stay out of prison if he followed strict court-ordered conditions. At the revocation hearing, the prosecution alleged several violations, including a new assault offense and failing to report to his supervision officer. There was brief confusion over one allegation, and after consulting with his attorney, Cardenas pleaded not true to the assault allegation. However, he admitted true to failing to report to his probation officer, a violation that alone was enough for the court to revoke his community supervision. Judge Stephanie Boyd carefully explained the consequences of his plea, making sure he understood that admitting the violation exposed him to significant prison time. Cardenas confirmed that he understood and still wished to proceed. The state and the defense then presented a negotiated plea agreement. Under the agreement, the state would dismiss further litigation over the disputed allegation and consider a separate pending assault matter. In exchange, Cardenas agreed to accept responsibility for the reporting violation and waive his right to appeal. Judge Boyd accepted the agreement, formally adjudicated him guilty, and sentenced him to 5 years in the Texas Department of Criminal Justice for each case. The sentences were ordered to run concurrently, meaning both 5-year terms would be served at the same time rather than one after the other. Because of the sexual assault conviction, he was also reminded of his ongoing Chapter 62 sex offender registration requirements. Before ending the hearing, Judge Boyd offered a final message that stood out. She reminded Cardenas that prison did not have to define the rest of his life. While holding him accountable for violating the court's trust, she encouraged him to use his time wisely, change his path, and build a better future after his release.